Thank you so much. Can you hear me all right? Good. Christian Bunky, working with Basque, been working with India for many, many years, so it's a pleasure to be here. I'm going to whiz through discussions and looking at a lot of comparison between India and Europe, try to pick out some areas where we think that there's a lot of some similarities, some areas to improve. From the audience that are here today, there's of course a lot of capable and very knowledgeable people in the crowd. Key things to take away just from the slides and from all of this is there's a big job to be done from everyone in this room to educate the industry and especially the SMEs, get them going with seeing the value of IP, understanding that patents are not everything. There's a lot of other things to do, and also I think also challenge the old way of doing things. Question, we've always done it this way. You might be working with people in US and Europe and in other countries who say this is how we've always done it. But there are a lot of different ways to do things and do things better. So yeah, I'm not going to bore you too much with my background and other things and jump straight into the slides. Let's see where I press on this. Good. Okay, we're going to start with some statistics. This, I hope you can see all the way at the back as well. Otherwise, I will read it out for you a little bit. These are looking at Indian filings. First of all, national entries into Europe, into India from European countries, so the priority countries. We can see Germany, all the usual suspects are there, right? So the big European countries. Very interesting to realize that this in some way gives away the companies who have a lot of activity in India where you probably will find a lot of your competitors as well. It sort of tapers off with some of the Nordic countries. I am Swedish, but live in the UK. So Sweden appears there as well. It's a small country, but they of course have quite a few of the companies like Ericsson and others. If we then look at the filings from Indian companies into Europe, we can see that there's not, a similar amount of filings, like around 1,000 or so, coming into the EP or the EPO. Now, I think we might be missing a trick here because we know that the official fees are quite high at the EPO. We also know, I have worked with India now for 15 years, and I know we're all very cost effective and cost conscious. Sometimes too much. And there are ways that we could do it and actually spend a little bit more money earlier and get more value. So for those of you who are in the pharmaceutical industry, fail early, fail cheap, basically. Don't spend too much money too much. So UK here, we have been pushing the boundaries a lot of the times. UK is one of the fastest countries for doing search and examination. We looked around at all the different PTOs globally, and we found that the UK IPO, when we were doing this study, they were doing the searches in 4 to 6 months to coming back with your search and examination. Now that's excellent if you are sitting and making a commercial decision on something. That has now creeped up to 6 to 8 months because I think a few of the big companies, we know some companies from Netherlands and others who are filing in the UK because taking advantage of this fast search and examination. However, if you are working with something like air filters for your combustion engines and these sort of things, you might be able to tweak your application. So just enter one little paragraph in your application that talks about CO2 savings, so renewable aspects. Then you get into something called green channel. So you get your search back in 2 to 3 months. You can also, now I'm going to give it away and we're going to have everyone in the room do this next week. You can also send in a simple letter that says this patent is of business critical importance for my company and I want to fast track it. No fee, just gets on the fast track, done, right? I try not to abuse it too much, but sometimes if I have a client that I really like and I think these guys are going to be the next unicorn and save the planet, I'll go for it. One little disclaimer here, especially with some of the people in the room, software is really tough. Software can be super tough. I don't want to take too much time, but I'll give you one quick. We've learned from this. So we had one company that had algorithms, clustering algorithms. We filed it. It was more or less the same algorithms in 6 different business areas. So we had biotech, we had drug discovery, we had different telecoms applications, etc. So it was 6 different business areas where these same algorithms were used. The UK IPO punched us in the teeth and threw out 5 of them. They didn't even search them. They said, this is software, non-patentable subject matter, no technical effect. What we did then, also at cost for the client, because we wanted to sort of show value and try to find a way around this, you can file in a lot of these other countries in English, right? So we filed it in Finland, same, so we picked the 5. We knew it was the same algorithms, but different application areas, so we filed that in Finland. They have now got a fast track option that comes back in 4 to 6 months. Sweden, Norway, Denmark, and Holland. Holland turned out to be tricky. There might be some Dutch friends in the room, but it was more probably than formalities than anything else. But we then got searches back from all of them, right? And even some of them started to say this was patentable subject matter. So that's things to think about, right? You might even, we sometimes do, because we have operations in the UK as well as in India, with some of our clients, we will file in parallel, right? So we've got the export restrictions for inventors being based here, but we'll file on the same day to sort of make sure we're compliant, and then we'll get the search back in the UK. That gives you importance to be able to look at what is coming back from things. I can see 1 or 2 hands one hand in the air, but that might have been a stretching. If you want to jump in with a question, please do, because I think it's much better that it's interactive than otherwise. Now, let's look at the US. We know the US is a big market. We know that especially for software patents, etc., it's great. So with some of the clients, we've just gone straight for the US. Number of Indian filings into the US is about twice, it's 8,000 there, right? So it's many more times than what we're seeing sort of between Europe and India. But if you look at the number from India, that's about twice, right? Again, I do think that there are things we can do there. You're probably all aware of the provisional patents that exist in the US, etc. That's something to be thinking about. I think from the Indian SME perspective, and from the power that exists in India from having been so I've worked with India since 2005, right? So there's a lot we can do for those sort of, I'm very much hoping we will have a bots for IP that does that first filing for them, right? Complies with what Moody said a few years ago now of saying, look, let's become entrepreneurial and get those startups going. And comes on to SMEs a little bit shortly, and we'll definitely touch upon that as well. Trading. So we all have to remember we are just a tool. I sometimes joke a little bit when people talk to me about, oh, you're into these patents and trademarks, it's very legal services. I said, well, really, I'm actually a little bit of a insurance sales guy. I'll sell you a patent that's like house insurance or life insurance. If someone comes and robs you, or the floods and whatever, you will use this insurance. If we look at the number of patents that are actually used, I mean, there's a few different reports. My gut feeling somewhere is that it's sort of 3, 4, maybe 5% of patents are actually used commercially in some licensing agreement or in some trade deal, whatever. But to be honest, the ones that then get litigated out of that, it's probably 10% of that, or even that, right? So we're talking of a fraction of percentage of these patents that actually get really tested and really hammered in court, right? So here, just important to notice, there's a big, I've been around long enough to, when we used to file patents, we used to always just file US, Europe, and Japan. Right? Japan was a pain. The Japanese attorneys doubled the fees when we were going in there. It was just the way it was. Now it's US, Europe, and China. We've even got a lot of our startup companies, etc., who might just say, look, we're just going to do Europe and China. That's where our markets are. Let's not worry about it. And they might actually just do UK, US, and China and be done with it, right? If you look at, so you can all be smart. We've got plenty of brain power and a lot of searching capacity. And I think that's one of the unique selling points of Indian IP work as well. We have got searching capabilities. So look, what are you benchmarking against, right? Several of the tech companies we're working with, we go in and we look, okay, who are your biggest competitors? Where do they file their patents? Oh, okay, there's a sprinkling of patents into Japan and a sprinkling into South Korea. But no way are people filing in all of these different countries. Don't go spend your money there unless you have the next Viagra, the next blockbuster drug, right? Again, we can see there's a lot to be done from a European point of view as well, trading with India. I think we're only the 9th largest trading partner or India is the 9th largest partner for. I know that, there's a long history, and I'm not going to pretend that I understand the UK and the England and the relationship there, but there's actually big opportunities as well, especially now with Brexit as well. So, soft services, trade is increasing. We can see here there's been a big increase. Probably a lot of you in this room are a reason for this. We know we have got setting up, in the early days it was Philips and GE and others who set up searching capacities. Now we're setting up drafting capacities. We've been doing that for 6-7 years ourselves in India, and it's great because we're actually working with US, European practice. Everyone needs to keep their head high and be really proud of what we're doing. China has been dominated big time from the foreign direct investment point of view into China versus India. From a European perspective, it's about half, right? So the double amount of money has been invested in China over the years. But I still think, again, from Brexit, being a Swede who would have, of course, loved to stay into the European Union, there's a lot of opportunity. From an IP, so pull it back into IP, Christian. Don't talk too much commercial stuff. Client of ours, Detroit Electric. They are the oldest electric vehicle company. The story goes that Henry Ford's wife didn't want to go in a combustion engine because it's noisy and banging and everything. She'd be horrified if she was trying to drive around in Cambridge these days with all these cars everywhere, or in Mumbai for that, or sorry, Bangalore for that reason. So this comes back to this power of IP, right? So we worked with them a few years ago. They needed to show intellectual property value. They needed to justify their valuations. We filed 40 patents for them in about 3-4 months, sat down with their engineers, harvested the ideas, and what we did, well, we used Green Channel, of course, right? What would you do? You've got an electric vehicle, filed it with the UK IPO, got Green Channel, responded quickly to the response. Again, we're spending more money earlier than sitting and waiting to the last day, but we're doing things. We got a response back, yeah, that looks fine, we'll accept those claims, asked for early publication. So it has to be published in the UK for 3 months before it goes to grant. And 9 months later from filing, we had a granted UK patent. That's excellent for them when they're going into China, because when you're doing your joint ventures, and that's the thing we all have to think about, is how you're building your business case. So you've got those patents, you're bundling them in. You've got the Detroit Electric trademark, you're bundling that in. It's know-how, it's engineering talent, it's confidential, trade secrets, all of this combined, not just patents. And that's how they then manage to justify this valuation, and that's their input into the joint venture into China, right? So that's when you're saying that intellectual capital, intellectual assets, justifies these valuations of hundreds of millions, but your IP is a key point in that. So I'll move on. Now, you might want to look at it. EPO was mentioned here earlier as a good source for reports and these sort of things. This is the high growth firms and IP firms report by the EPO, May 2019. If there's anything I want you to take away from this here, it's the relationship between SMEs and corporates, right? So how many of the SMEs would want to be licensing their stuff? Well, of course, 48% of them. I'm a small supplier to one of the automotive companies. I'm a small supplier to Tata Consulting Services, these sort of things. I want to be licensing my stuff. How am I going to do that? How am I going to have something tangible? Well, patents is a great starting point. It's not everything, but it's one way to lock something down. Actually, it's about a third of them who are licensing into the big guys, right? But just look at when it comes to the patenting, so this is EP patents. I had to try to figure out why is the number so low. And I racked my brain with this. So of the SMEs, only 0.8% of the SMEs are filing patents. But what is it? It's actually EP patents. And again, it's like yourselves. It's the expensive $3 grand for the official fees for this EP patent. The European SMEs aren't filing it, they're filing nationally, right? So they're going into, they maybe have a German patent, and then they have a Gebrauchsmuster, which is the sort of petty patent, utility patents, not using utility in the US sense. And about 10% of the big multinationals. But in most countries and in Europe, if you look at statistics, it's still dominated by the big guys, right? We've got all the Japanese, we've got all the Chinese guys doing lots and lots of filing. However, an example, Nokia imploded. I used to work with the Nokia mafia. My co-founder of Alban, our IP platform, is one of the top inventors at Nokia. Finland has now had SMEs and startups overtake the big multinationals in number of filings. These are the trends that are happening. So very important. I had a little bit of a chat during one of the coffee breaks here as well, that the European companies, they understand the value, especially the SMEs. So the Mittelstand, this multi-billion dollar industry in Germany, which is fueling the German economy, right? They're all suppliers to the big guys. I think from this slide, they're in the same report, it says that 70% of the patents from startups that crash have been resold, right? Now, yeah, true. I mean, I'll give you an example. AdBrain, startup company, media tech company in London that we worked with. We filed lots of patents for them. We got some progress, some less so. Company ran out of money at some point. And then that's when they're sort of trying to salvage it, right? How are we going to get some value out of this? And normally you then sell the existing assets. You know, it'll be the code that they've got. It'll be a few laptops and servers, but that's not much, right? And then it's the patents and the trademarks, right? So that is when you then attribute the value of these. In that case, it was a few million that they got, and they could then, attribute that value and got some money back for the investors. I have done a biotech startup, spun out of Cambridge, fantastic story. We were building these services, diagnostic tests, etc., but we ran out of money. We crashed. We sold the assets to Amersham, which is now GE Healthcare. But, I can spin it as a story of we sold our IP, but that's how it goes. Look, here the main takeaway really is just that the future is in the SMEs, right? They are the companies that will create jobs. We all have a tendency to go to that safety. I would encourage anyone who can step out there and do a startup, generate those jobs, create the buzz. That's where the future lies, right? And we as a profession, as an IP profession, have to take our responsibility and support that as much as we can, right? Don't yank up the price when the inventor comes who doesn't have the purchasing power. Good. Yeah, we've talked about a lot of the other stuff. I will mention one thing, though, and I think that is, I am a European, I'm pro-Brexit and against Brexit and these sort of things, and you can say whatever you want about the leaders that we have right now, but so in the UK it's Boris Johnson, right? I'm not a big fan and these sort of things, but some good friends of mine who are running the company O2H, some of you might know them, they're Gujarat, Cambridge UK, Cambridge US, investment fund, sold companies to Piramal and stuff. They had a session and they were sitting around asking, what do the biotech people, pharma people think about the UK now with this new government? And actually putting political things aside, they actually felt that it's a good time for industry and science. And this is proven in some of the reports as well. So there's some recent reports that have been in the media, and you can just do a quick search. You can just see venture capital investments in US, Europe, and China, and you'll get it up. And I think it was last month. So UK is now outperforming China and the US in fast-growing tech. Of course, fueled a lot by financial fintech, of course, but also in pharma, life sciences. Trying to think, where is the sensor for this? Yeah. SMEs and IPR. You will have a session, a panel a little bit later here, and I think one thing that's often really underestimated is speed, right? Speed. We're getting to a point now where the turnaround time is so quick, right? The big guys are acquiring the small companies so fast now, right? The due diligence is super fast. And that is, so I'll give you another example. We worked with a company called Grapeshot, software company out in Cambridge. Their CEO, so I'm not breaking any confidentiality, their CEO has stood up and given presentation, John Snyder. John's a great guy. I am a patent guy. I'd like to sell him lots of patents. We were handling his patent portfolio. We had one patent. And that was filed before they went into a meeting with Google because, you know, to sort of safeguard. But they were really big believers on freedom to operate. Freedom to operate, fast moving, getting a few lucky breaks in the industry, and keeping their source code clean, right? So when Oracle came and acquired them about 18 months, probably 2 years ago now, they would do the due diligence, they would check, is the source code clean? Yeah, copyright for that, that's fine. And there's no real open source conflicts in what they've developed. They have a patent. Yeah, it was really important to us to keep that patent alive in the last few months when things were happening. But that they still did a huge exit. It's one of the big exits that have happened in Cambridge. So keep in mind those sort of things. Commercial exploitation, prevention of imitation. Well, we have also seen there's good ways of designing around things as well, or re-engineering. The management, I think if I again come back to this point of trying to find things that I use when I'm selling in and differentiating ourselves against in the IP industry. You guys have got huge knowledge and you've got some of the best patent searchers in the world right now. A lot of the UK, US firms have sort of said, oh, well, we'll just do the drafting and file, right? And we'll see what comes back. You can do, spending that money up front. Again, it's maybe spend money on doing a really quality, good search at the front. The attorney will be able to draft better claims. Will be able to know what is the landscape, what's going on. I'm a big believer in doing patent landscapes and then putting a patent watch in place, right? Put the patent watch in place and keep up to date, and that keeps building your landscape so that you're knowing where the competitors are. I'm doing a project right now with a startup that has filed, a dozen or more patent applications straight in the US from one of the biggest firms in the UK, but they have no idea. What's the competitive landscape? Is there a showstopper that they haven't even looked at? And they've spent lots of money doing this. So again, coming back to this, education, commercial understanding, you guys knowing how you can advise these people how to get the search done. Get the draft done. Keep maybe a short draft first. File it multiple times. File for search in the first one, then file it with just filing fee, right? And file it on the same day here. Pick Sweden for all I care. Get my buddy John Yuan to do the search for you. Reasons for the gap between the sort of SMEs and these things. The UK have done some good initiatives that I think India should take a look at. I was sort of thinking about this before coming up to give the presentation. I'm thinking the crowd here and us, we have to work on the education, quality of work, speed of delivery, right? Forget this world of where you can say to someone, it'll take you 6 weeks and you'll have a patent application. Come on, we've got to be as fast as the company who needs our services. But political, there's, for those of you who might have some connections in that world, push them, right? They have to be able to set the landscape so that things can happen. So in the UK, we've got something called the patent box. And it's unfortunately today only used by mainly the large guys. And patent box means that you're lowering your corporation tax to 10% if you have a patented technology, right? So this is one of the reasons they said Pfizer and AstraZeneca were looking at acquiring each other. It was big times a tax play to be able to flip the business into be a UK company and pay less corporation tax. Of course, government stepped in and stopped that, and as a Cambridge person with AstraZeneca as the headquarters in Cambridge, I appreciate that. But using Sally Curran, the head of patents at AstraZeneca, as an example, I put the question to her a few months ago, is there a need for the IP industry to change? Right? In this fast-moving world where things are moving so fast, how are the big pharma going to be able to collaborate with the small companies, and how are we going to have to change? And she said, you're absolutely right. We have to be faster. We have to make decisions, maybe have a little bit more risk. If you keep pushing for that ideal terms at the early stage with a fast-growing, smaller company, you'll probably kill the deal or you'll kill them, right? So you've got to take a few risks. You've got to work maybe with more open innovation. You've got to work with your patenting faster, better, and using tactics. India, we know we have a problem with the court system. I was sitting with so we are active in India. We are also now active in Brazil. And I was sitting with one of the guys from Philips, and he says, yeah, maybe India just pips Brazil, or Brazil just pips or just gets ahead of India when it comes to the court system, right? That is it enforceable? Can we get results? Can we get decisions? Just as again, thinking about where we have to work, I went and saw Micromax, told them they needed to go and buy and find patents so that otherwise they would be sued. I'd just been working with all the Nokia mafia, as I call them. That was 1 year before they tried to do their listing and they got sued, right? They sent me a trademark person to talk to me, right? It's these things that need to change, right? And you are the guys who can do it, right? Make sure that, I sometimes joke, I say, we're a bit unfortunate getting into this industry because we can never get out. No matter where you are, there'll be some meeting where someone says, oh, we got this issue with patents. Hey, anyone here with any experience of patents or trademarks? And you're stuck with the project, right? But be smarter, challenge always what people are doing. Comparing the systems, technical effect, of course, is the big one when it comes to software. India is also tough with software because it takes after a lot of what we're doing in the UK. European Patent Office is coming around now to software as a patent. From a life sciences biotech space, a lot of the big pharma are moving into digital health. Digital health is huge. There was an article in the New York Times 2 days ago. I was reading it on the plane over. David Brown, the inventor of Viagra, was talking. He's also the co-founder of Helix, one of the startups that we have around the corner of us in Cambridge. Tim and David are the founders. They are working with AI for rare disease drug discovery. They are also working with confidentiality, keeping their algorithms safe, making sure that they're running just like Patseer, have amazing algorithms that are proprietary. But then they look at the patenting on the drugs, right? Patenting on the actual drugs that are coming out. I think that's pretty much it. It's behind there. I found it. This is really, are we doing all right time-wise? We're fine? Yeah, I'm going to shoot. I'm going to just go really as fast as I can in that sense so we catch up on a few things, but do say if there are questions. Looking at some of these sort of tactics then. So this is the typical, I think we copied this from the EPO's website, and so this is basically the typical flow that we would have with the European Patent Office. Now, if you do the first filing with the European Patent Office, you don't have to pay for examination straight away, right? So depending on the priority filing, if you've done whatever, but if you're going in at 12 months or or the first filing is done with the EP, it's not, it's 1,500 euros or about there for the search fee, right? The filing fee is about, if you're doing electronically, 230 euros or something. But the actual examination fee comes 6 months after the publication of the European search report, right? And so that's when, your 18-month publication, and then it comes in after that. So you can actually get quite far with getting a really good quality search done, right? Now here's another hack for you, and I'm probably going to do now the rest of India is going to hammer Luxembourg, because if you file in Luxembourg, the EPO has some agreement that I learned this from the universities, Cambridge University's Tech Transfer Office. They sometimes file in Luxembourg because the EPO has an agreement that we'll do your search for you. So you're getting a European search by filing in Luxembourg. You can try it if you want. There. So this is the typical flow. I think there's some thinking to be done. When I see that chart of Indian companies filing 1,000 European patents and 59 in the UK, I sort of wonder, are people categorizing their inventions, right? Are they categorizing are they putting the commercial value on these ones? Maybe it's a case where all of those 867 patents are really valuable. Fine, totally got it, agree. But I'll get to the next slide in 2 slides down and tell you what you should be doing then, right? But maybe there is a case where, right, we know our biggest competitor. Where do we file our patents? We know it. It's where you have your competitors, where you have your biggest markets, where you might have some manufacturing or production yourself. So all of those things are always important to keep in mind. This is all the way through. Validations is the last thing at the end. Validations is, of course, when you get to a granted European patent, where do you want it to be valid, right? So this is a laborsome process. you will actually have to translate it. There's the London Agreement that means basically Northern Europe. You have to just translate the claims. Now, here's another, I'm stealing the thunder already from the other slide, but when you get a granted European patent, UK, France, and Germany is already done. You know, your European patent attorneys will charge you for it, for validating in those countries, but it's already done. Because you actually have to, when you get the grant, you have to translate into German or French. So that's actually already done. And then, you know, we have to feed our kids as well. So yeah, I'll charge you maybe, I don't know, £120 for validating in those countries, right? But it's not a 500, 600, 700, £1,000 job, right? It's done. PCT, right? I'm seeing a trend more and more, especially if the companies are reasonably well funded and they have a clear strategy already where they want to go. Why spend the money on a PCT, right? Yeah, it's great if you need to be able to show that you are patent pending globally in all these 150 plus countries, do it, fine, right? Some of the really smart, well-funded startups are saying, hey, you know, I'm happy. I'll secure the market in, you know, right now it is basically US, Europe, and China. I wish, and I can sort of feel, maybe in 5, 10 years, maybe 10 years, it'll probably, you know, I hope it'll be US, Europe, India, and China, right? I think it could be, right? Depends if we get our act together and things start happening. Now, if you do use the PCT stage, what's another good tactic to do? Well, I think the next slide actually tells it. I'm going to jump forward and I hope I can jump back later. If you use the, you know, okay, so you're thinking, so you've got pressures from your CFO and he's saying, okay, great, file the PCT. Which international search authority should we be using? Oh, cheapest option, India, let's do it, you know, great. I sat with Francis Gurry, the president of WIPO, and had lunch with him when India was just becoming the International Search Authority. And that was a great step, fantastic. But, yeah, you're paying 1,300 euros for you know, filing with Indian IP India as a search authority. Then, when you're coming into EP later on, you're paying full whack. You're paying for the search and for the examination and the whole shebang. Now, EP validations, I've sort of put that there to challenge you all a little bit. Like if you were to validate in all of the countries, 32 grand, right? Not many people are going to do this, right? I mean, at some point you might say, okay, not too sure it's too important in Monaco and Luxembourg. You know, you might have a nicer roulette wheel, but it's unlikely. It says 0 up here on these countries. That's again, I wish I could say I'd put that there to shock you, but it's like 60 quid in the UK for the filing fee. It's very little. You can actually file sometimes to just get the priority document, stuff and not pay anything, but there's some small fees involved. If you go in and you put Europe as your international search authority during the PCT, you'll pay more money, right? You'll be paying more money to get the search done by the EPO. But you're getting the best, no offense to the Americans in the room, you're getting the best search in the world, right? Even compared to the UK. The UK examiner's under huge pressure, you know, they're doing all this fast searching, but the European search is second to none, right? There might be some cases where it's not worked well. But if you put the money up there, this is again, fail early, fail cheap, right? You'll get the search done during the PCT stage by the EPO. So when you go into the EPO, you don't pay for the search, it's done. So you don't have to pay for the search, it's done. And valid, you know, and then it says down here, you know, examination fee. It's not, the slide's slightly misleading because you actually have to, that's the more if you take that tactics of doing a chapter 2, right? I'm old enough to know when chapter 2, phase 2, blah, blah, blah was, you know, we all paid it to get to that 30, 31 months, right? Now, if you pay for chapter 2, yeah, it's going to cost you 2, 3 grand or so because there's official fees there as well. But then again, you get a discount on the examination fee because you've already had the forwarding and backwardsing with the examiner, right? That's where you have to be tough on the European patent attorneys to not charge you a fortune for the office action. So get them on fixed price, Make sure that, you maybe support, do some of the drafting for them, give them the key things. I mean, some of those in the room here who worked with CPA and the Microsoft team, the story goes, if I want to spice it up, I say it's Bill Gates, but I'm sure it wasn't Bill Gates. But, doubling the number of patents without increasing cost, right? That was done by using really smart Indian brains, right? Yeah, so then if I jump into the validations, I've already mentioned it to you, right? The key markets, Europe, Europe, UK, Germany, France, it's already done when you've got your granted patent. Is it really worth filing in all these other ones? Benchmark, come on, you guys have got the power, you've got the tool, you've got some searcher either in your department or you've got a good alternative that you are working with already in the US, in the UK, in India, I don't care. You've got, you get good guys to do this. Check where their validations are. Right? We did this for one large multinational in the fast fashion industry sitting in New York. We looked at them, okay, this is where all your competitors are filing. Oh, okay. Oh, why don't we do Switzerland? Yeah, great, because Switzerland, CH, it's also free. You don't have to do any translation because they accept German in Switzerland, right? And again, the patent attorney you work with might charge you 100, 200 to just file because you change the address of communication or correspondence in those countries. But simple. Belgium's also come along and do the same thing. The southern European countries, a little bit, still not on London agreements, still do translation of the whole thing. But hey, if you are competing, I saw Spain was quite a big country of that, filing from India directly into Spain. That's probably because there are some big competitors to the Indian companies in Spain, or the Indian operations have their own manufacturing there, so you want to protect it. So then, fine, take the translation cost of Spain, 1,500, but at least it's done, right? I'm going to jump back 2 slides. Can I do this? PPH. Everyone know Patent Prosecution Highway? Know what it is? I sometimes talk about reverse PPH. That's because I try to be fancy. I've never really pulled one off yet. But if you get a successful, say you're doing that, you're spending that little bit extra money during the PCT stage and you're using the EPO as your International Search Authority and your IPER office. If you get a positive response there, you whack it into all these other countries and they accept your decision. Right? As long as you keep the claims the same, you get a grant there. So you're saving money again, times X in Canada and USA and all the big 5, right? I'd be surprised if you couldn't go back after this tomorrow and figure out that we could actually save a bit of money if we just, spend a little bit more money here or there and just do it slightly differently. I'm still waiting. When I say reverse PPH, that's the one where I'm waiting for the filing software patent or the getting the grant. If I had filed that Detroit Electric patent in the US and got that quick grant, then I could use the sort of, if I'd filed first in the US and then UK and then get it in and get them to accept the claims. And of course, when I was part of building a large patent portfolio in mobile advertisement, which we sold to Apple, we always made sure we kept patents pending, right? So if you're building that patent, you're getting it to issue, file a divisional. If it's the gold nugget, file a divisional so the claims are right. Because otherwise, there will be some smart Indian guy up here, reverse engineering your mousetrap, right? So, be smart. File the divisional. Do continuation in parts. I've seen, in the last 6 months, I have had guys come to me with inventions they did in 1998 that read on Twitter, but they've not done it properly. And that's what we're going to be with the Indian startups, etc., if they don't get their act together, right? I'm not saying file lots of patents, but file a patent or 2 here. Get your portfolio in place. For those of you who are in the startup game, one startup we work with, they have Sequoia as an investor. Sequoia is the big guy who's done Twitter and Facebook and all of these. For this company, so it's a specific case, but every new patent family they file adds $1 million to the valuation of the company. Right? It's pretty nice when you're in that A round, B round phase to file, okay, well, let's get 30 patents done, right? So, patent prosecution highway, really important. We were one of the biggest users of it when we were building the portfolio in mobile advertisement. We were using it all the time straight into the US. It was just when it was sort of kicking off. I mentioned the divisionals. Make sure you file them. The US, it's a big thing. Europe, you can also, in Europe, you can also do divisionals. The European divisional has to be done before the publication of the date of grant. So basically, they tried. There was a bit of abuse, however you want to see it, by companies who were waiting a long time. Yes?
So with regard to divisionals, I just want to say one thing, that in EP, like in Europe, is there not a prerequisite condition that the invention should be distinct for filing the divisional? Because in India, the provision which actually deals with it has, and there are many case laws also, that says that the invention should be distinct. Means the application should define 2 different inventions for filing provisional. So the applicant can file it pro bono or after receiving the first examination report. But the main key for filing those is that lack of unity.
So in Europe, as long as your claim scope overlaps, so you have to have a different claim scope, right? So I have not had a case where, or I haven't heard of a case where you get hit on that distinctness. It's as long as you are mosaicing a bit, you're getting a different claim scope and adding another feature or removing another feature. Of course, Europe is tricky because there's a lot of focus on support in the description, which is really important for Indian drafters, right? We know a lot of companies still rely on drafting in US and Europe, and that's because when we're drafting in India, we are a little bit sloppy in having the support for in the description. It's something we've worked really hard with, but it's really important. You're absolutely right. We had a case, we took over a biotech case that was in India because the Indian firm filed a divisional just with the same claims as in the first application.
Yes.
And then we were stuck, right?
Yes. And in India, it is not possible also because Section 16 objection will come and the controller will not get to allow it because we have handled so many cases, just to keep the patent pending.
Exactly. There was some delay in filing the
Unlike
response.
Australia, in Australia you can do that. In Australia and New Zealand, you can just file the patents or keep the patent pending. But in India, it is not the case.
Exactly. So thank you. There's another hack that we've just revealed. Do not file your, make sure you have that distinction. We ended up taking over a case where the Indian firm had not added enough differences in the divisional. Yeah, and in Europe, in some of the things in Europe, UK doesn't allow double patenting, and I think that's a little bit where this comes from. The UK, and it's still common law, it's still a lot of connections in the systems. What we do, we will sometimes in the validation, we will keep the UK grant if we have one, if the claims for that one is better than what we ended up getting in Europe. First of all, you've got 2 different patents. So if someone's going to come after you, they've got to have to kill you in Germany or in another place with the European one. And then the claim scope is different for the UK one, right? Again, when we're talking about the validations, think about litigation, right? Where will you be litigating, right? I know Nokia slows down the litigation by countersuing and litigating in Italy, right? Because it's slow. So yeah, maybe then it's worth having validation in Italy. I would say probably in the fast-moving pace we're now, probably not. Even when we validate and we don't decide not to validate in the UK, we are actually cutting 1 year off our patent life because we've got 20 years from filing. If that was our first filing, and then the PCT or EP filing is done 1 year later, you actually got 21 years for the same invention, right? But we're happy to maybe give away a year if that means we've got better claims for that first one. From a litigation point of view, Germany's excellent, really high caliber judges, courts, technical as well as legal. Holland's pretty good, very good. I think also for some of the sort of software stuff, they're pretty cool. UK, quite expensive and not very software friendly. So if you get hit by a European software patent, you know where to go. Not to me, we don't do litigation. Express grant, we've touched upon it already. We're starting to do a few of these now for some of the companies who want to show the value. So Brazil, for example, where we're active in Brazil and China. And not in China, we have partners in China, but we will use the sort of PPH, Patent Prosecution Highway. You can even get a lot of this stuff done even during the first year. And then it's also about, thinking about improving your patent application by the 12 months, right? Sometimes what we will do is that we'll file the first one, and if you then have, you might have a follow-up discussion with the R&D team 3 months later, and they've said, oh, we've seen this and this and this as well. So all right, so you do the first filing ABC, features ABC. Then you do a second filing ABD, right? Because they've come up with this new feature, D, C wasn't that important. So you file that one again, but you might actually file it without claiming priority. So because you're within the first year anyway, you can just file the first one 1st of January, second one 1st of April. Hopefully it's not a joke. And then you go a few more of those. And then when you get to 12 months, decide which ones you pull together. Actually, I'm not sure I want to disclose D. D might be something I want to keep confidential. So then you pull in the first one, A, B, C, and the third one, A, B, E, right? Whack them together as your 12-month application and remove anything about D, and you keep that as confidential know-how, and you've got a really strong patent. And you will have done it if you then do a search. So, okay, I'm fine. File it in the US first, but then use your capacity and your knowledge that you have here with a lot of good searchers. Do a really good search so that you know what is the prior art and how you're going to handle that, and build in to your drafting the back doors and backstops that you have in your application. Cost savings. Oh, God, do I have to talk about it? Yeah, short applications, not too short. US can get into trouble with enabling embodiments, these sort of things. Validations we've talked about. For the European style, they really want you to have full, repetitive support in the main disclosure. Some of the big multinationals we do drafting for will really have to be careful, and they become very long-winded. If it's a startup, just shorten it down. You can always copy in your claims later on into the main description, but you have to be really careful with added subject matter. For those of you who are not drafters or who are going into drafting, you will all fall over on the added subject matter. It's so easy to add. In Europe, they will be really picky with the wording. Talked about the fees and reductions and stuff. That's it. Any quick questions before I hope I didn't make you fall asleep? Yes, sir.
I have an observation on the slide where you had these PPH.
Yes.
So there's something to add to the contents of that slide?
Yep. Which country am I missing?
So one is, no, it's not missing it. I mean, just want to add that there's a formal PPH between these countries and EPO.
Yep.
But there's an informal PPH, if I may use that word.
Yep.
Because a grant of a European patent can be used to expedite the examination of a patent application in Vietnam, Chile, Mexico, Indonesia, Malaysia, Cambodia. Cambodia has formally signed an agreement with EPO, but these other countries, they haven't signed. Yet we can expedite the grant in these pending applications in other countries. Yeah,
very good point. Take it on board. And even so, I think maybe it's the old relationship between India and the UK. If we have a granted case in the UK, we quite often get reasonably positive
it's like it has a persuasive effect.
Yeah, the examiner will take that on board. And I think that's why the patent officers are under huge pressure of the backlogs, right? They are not keeping up. That's why we need technology. I rave on with Alban, the platform we're working in, some of the AI machine learning we're doing, because we're in Cambridge where all the exciting AI stuff is happening. But of course, like Kaisa, who works with us, who's the editor of VISA, the EPO, annotated EPO book, she always says, yeah, but Christian, remember, the examiners will get the tools as well. So it is, this is a race we have to work with and work with, trying to reduce the work smarter. So thank you for the input. Anyone else?
I have one comment on the statistics which you showed that SMEs are not very prone to file patents in Europe and outside India. So one comment is that for Indian SMEs or startups, basically funding is the issue, the basic issue. And the other thing is that most of the startups and SMEs, they don't have primary market focus on Europe. So mostly they try it in India, then they go for China, and then if it works, then it goes for Europe, and then it goes for patent filing and that. So at that time, mostly priority dates and 30 months and all that has gone. So filing this in Europe, that most of the times don't work. When we convince, from the patent perspective, when we convince startups, they say that we don't have any focus on, we don't have any this thing in filing in Europe in near future. So
yeah, I agree. I mean, look, it is always about this. I wouldn't call it IP strategy. I'd call it more IP tactics, right? Where you want to file. But if you are an Indian startup, you're software heavy, you know, whack that patent into the US, right? And also, South Korea is very software friendly, right? So maybe that's a place as well. If you think you're going to sell to Samsung, right, or LG, right?
Even from pharma perspective, most of the times, first priority, first focus is on US and then Europe. For obvious reason that in Europe it's quite difficult to get, not difficult, but it's complicated to get patent, and then again it's costly.
Yeah. So we've managed to, for software, for example, we've managed to get some. So we work with one of the largest games companies in the world, and we file a patent on every game that they launch, and we've managed to get them granted in Europe, but not in the UK. If you dig enough, you'll find who it is. Totally take that on board. I think the other little hack I might try to suggest, and I haven't covered it, China, right? So China has still got that two-patent system, right? They've got the normal patents, and then unfortunately called a utility patent, which is the petty patent. Yeah, utility model, yeah. And they're not really software happy on the utility model, but they will grant it more or less straight away. So with some companies where you do need good grants, especially if you're going into negotiation with the Chinese, right? The Chinese are really patent focused right now. So India has to find your way, right? Your model. And then play the game, find your way, but play the game knowing how they're going to play the hand, right?
That's very important, because Chinese, they play in very different the business model is completely different than Indian or other than the world.
You know, look, I have a massive team, a great, fantastic team in Noida. I avoid playing chess or noughts and crosses with my team there, because they beat me every time, because you guys are very smart. And that's what you should keep thinking about, right? Find your way. Is it with speed? Is it with short applications? Is it maybe then filing it into China, maybe dual filing, you know, one as a patent and a utility model, get the utility model granted quickly so you can show value in that JV discussion, right?
Yeah, let's go to that India filing in Europe.
Yes, India filing in Europe, yep. First filing, like the European one straight away, without PCT, this one?
No, the first one, initial one. That bar chart. The bar chart.
Yep. Got it. Shoot with a question while we're off sipping through here.
Yeah, here you say.
It's coming, it's this one.
That's right. The bar filing in Europe from India is really large one, whereas in other countries hardly anything. Yep. But in Europe, even though patent granted, unless and until validated, it's not enforceable at all.
Yep.
So does it mean that patents, even though filed in Europe but not validated in other jurisdictions?
Does that mean that they're not enforceable?
Yeah, because unless they are validated, they're useless.
These are all a smoking gun until they, well, not a smoking gun, a pop gun, until they are fully loaded when you've validated.
Yeah.
But what you might want to, so I'll give you another hack. Big Swedish, how am I going to describe them? Engineering company, right? They're working in the sort of mechanical space. They were troubled by a European patent. So what happens in Europe when they get granted? Again, all of you guys who are working with clients, put the European watch in place of the competitors. You know, it's a great tool. File European oppositions against these guys before they get in, and you have to spend on court cases and all this. That's why the US have done the IPOs to sort of follow suit on that, right? In some ways. Now, the counterparty was very smart, because they had a pending, it was about to grant European case, and this big Swedish company jumps in and does an opposition, right? That's exactly what I would have advised them. The other guys were a little bit smarter. It was probably an Indian company. They filed a Gebrauchsmuster, which is the utility model petty patent in Germany. What happens? It gets granted straight away. So all of a sudden, you've got this 9-month opposition period that's then going to go take months to resolve, etc. And now they're suing you or threatening you with a granted utility. You know, it's tactics of quick turning those thumb screws, putting pressure on them, right?
Don't forget the injunction.
Yeah. Yeah.
That's
Yeah.
where you can get injunctive relief, stop sales,
Yeah.
game changer.
Exactly. So the comment back in the front here is don't forget the injunctions, you know, to get people to stop their stuff, right? And also every country in Europe has slightly different laws, right? You know, Germany, France, UK, there's slight differences in each one. When you sue someone or you take a fight, pick your court, right? Pick the right one, right? Cool. Anything else? Are we more or less there? You can always grab me later on, happy to, and even afterwards if you ever have any questions. I think my number is on emails on there, or otherwise you can find it here or via my partner, Gowan Kedia, who's most of you probably know. Thank you so much for the time.
Thank you. Thanks a lot, Christian, for such an informative presentation. So let's take 10 minutes tea coffee break and really come back in 10 minutes.